How we doing today, guys? It's Jesse with the Common Man, Corpus Christi, bringing you some news and politics through a common sense lens. Apologize about the throat. Weather's changing around here a little bit, and it always messes me up. So, we're going to start with a couple of other things. We're going to go over the Kyle Rittenhouse trial. We're also going to go over the OSHA rule enforcement change that currently just happened. And I'm going to review a little bit of the actual court decision as well. So let's start right off with the Kyle Rittenhouse trial. Now, if you haven't been paying attention to what's been going on in this trial, I highly recommend you go back and look at some of the news articles from it. This thing has been an absolute disaster from the very beginning. The defense has been, or the prosecution has been absolutely horrible. They literally more or less proved the defense's case during the time that they were presenting their case, between their own witnesses admitting on camera, or not on camera, obviously, because it was videotaped, but on the stand admitting that they were not fired upon by Kyle Rittenhouse until they pointed their own gun at him, the one guy that survived the whole incident. So yeah, it's been an absolute mess. So this is, there was on one of the days of the closing verdicts, which was just on Monday, the prosecutor picked up an AR-15, put his finger on the trigger, and swung it around the courtroom, including pointing at the juror. They're pictures. Go check them out. It's insane. Like this, it almost feels like they're intentionally swinging the trial. So let's look into what the latest news from that was. This is some wild stuff that just broke the other night. Rittenhouse prosecutor withheld high-quality video from jury. Now this leads to one of the most recent motions to file a dismissal with prejudice. That one came out initially the very first night when this came out, and now there's been another one. There's two motions to file for a dismissal, one with prejudice and one without. So let's check out this one. The failure to provide the same quality footage in these particular cases is intentional and clearly prejudices the defendant, per the defense's motion. One of the other things the defense did, or the prosecution did during this trial, was also question Kyle's Fifth Amendment rights on the stand in front of the jury. That is a huge no-no. He basically flat out asked him, why is this the first time you're telling your story, when Kyle decided to take the stand, okay? It is your God-given, constitutionally enshrined right to keep your mouth shut and not incriminate yourself by saying something stupid, or just something in general that might be construed in a way to make you look guilty. That's the whole point of your Fifth Amendment rights. This should be law school 101. I learned more when I went to a week-long thing in Washington, D.C. So, that was just one more thing they screwed up. So this is just the latest in many things that they've screwed up. Assistant District Attorney Thomas Binger, this guy should be disbarred, could have shown that the jury was serving on, have shown the jury serving in Kyle Rittenhouse murder trial a high-quality drone video of the event of August 25th, 2020. That's the night of the shootings. Instead, he showed the jury a low-quality footage and only showed the drone footage during his closing arguments. He claimed the video showed the then 17-year-old pointing his gun at people. Trying to keep the throat going, guys. Rittenhouse's defense team has subsequently asserted that the prosecution only shared the video after evidence is closed on November 13th. The Daily Mail obtained the motion for mistrial with prejudice that has been filed by the defense. So that was the one they filed the first night. The outlet reports the video maneuver was one of the grounds cited in the motion. On November 5th, 2021, the fifth day of the trial in this case, the prosecution turned over to the defense footage of a drone video which captured some of the incident for August 25th, 2020, the motion states. The problem is the prosecution gave the defense a compromised version of the video. It continues. What that means is the video provided to the defense was not as clear as the video kept by the state. The defense contends that the prosecution did not provide the 11.2 megabyte video until after the conclusion of the trial. Instead, they were only given a lower quality 3.6 megabyte. So you're talking literally a third of the file size. That's a huge quality difference. You're talking about the difference between someone's potato cam on their cell phone in like 1997, their little crappy camera phone in like the late 90s, early 2000s, compared to literally the high quality HD video footage we have today. It's absolutely mad. All right, so let's get back to the news article. The video footage has been at the center of this case, the defense wrote. The idea that the state would provide lesser quality footage and then use that footage as a linchpin in their case is the very reason they requested and were granted the provocation instruction by the court. The failure to provide the same quality footage in this particular case is intentional and clearly prejudices the defendant, said the defense in a mistrial motion. The prosecution's conduct has been hotly contested during the case. 88 Binger has been repeatedly reprimanded by Judge Bruce Schroeder throughout the trial over his conduct. Go back and watch those videos. They are hilarious. It's a miracle that judge wasn't flat out screaming at the dude. You could tell he wanted to just chew his head off. He was flabbergasted by some of the shit that came out of this prosecutor's mouth. It just blew me away. At one point during his examination of Rittenhouse, Binger had questioned the teenage boys and stay on the silent after the shootings. I was astonished when you began your... This is coming from the judge. I was astonished when you began your examination by commenting on the defendant's post-arrest silence. Schroeder shouted. He definitely had his voice raised. At Binger after stopping the trail and sending the jury out of the room. That's basic law. It's been basic law in this country for 40 or 50 years, Schroeder said. I don't know what you're up to. During his closing arguments, Binger pointed the AR-15 used during the shootings at the jury with his finger on the trigger. His actions were decried online because experienced gun owners advise treating every gun as is loaded for safety, which is exactly what you should always do. If convicted, Kyle Rittenhouse faces life in prison for fatally shooting 2 men and injuring another during the riots in Kenosha last summer. Rittenhouse and his lawyers have argued that he acted out of self-defense and has used video throughout the trial as evidence. The jury deliberated for a full day on November 16th and has not yet returned with a verdict. Okay, so this article was a couple of days old, but nothing really much has changed. These motions were filed. Basically, it's been the same thing ever since. It really hasn't, not much has changed in the last few days, or in the last couple of days. Nothing really has changed in the last 24 hours. The judge is still deciding about there are 2 motions to dismiss up now. Like I said, one with prejudice, one without. The one without prejudice was presented during the actual court proceedings when they were talking about some of this stuff. The other one was actually formally introduced. So it's one of those things like this case has been an absolute mess. If any of you saw the raw footage from people like Elijah Schaefer and Ricky McGinnis and some of the other guys, some of these guys were even presented as witnesses in the trial because their footage was so compelling and they were on the ground watching this happen minute by minute. So I highly recommend you go and checking out their footage. This is a clear-cut case of self-defense. You know, what did you expect to do? What did you expect this kid to do when he was watching his community, his business, the place his dad, the city his dad lived in, literally getting burned? This was the 3rd night of riots. It was either the 2nd or the 3rd. I'm pretty sure it was the 3rd night of riots when this happened. Okay, they had already burned Kenosha for 2 nights in a row before this kid went out there to defend property. Well, when the cops don't show up, what do you expect to happen? So pundits can argue all day long they want if maybe he shouldn't have been there. Well, yeah, you're right. He shouldn't have been there. He shouldn't have had to have been there. The cops and the state and the elected government officials should have been out there protecting their cities. So, but I digress. That's the update on the Kyle Rittenhouse trial. So now on to something something that made me very happy because something that affects my own personal life as well. Because my wife actually is a manager for a local retail outlet, and she had just got notice from her company, I believe on either Monday or Tuesday, that this was coming and that they were going to start enforcing this. Fortunately enough, this just happened yesterday, so I was super excited. I was over the moon as soon as I saw this on Twitter. So let's read this article and we'll go into some of this beautiful, beautiful language in this court ruling. Breaking. OSHA suspends implementation and enforcement of vaccine mandate after legal challenges. It's from November 17th, so yesterday, by Lee Hammond. The Occupational Safety and Health Administration, OSHA, within the Department of Labor, suspended the implementation and enforcement of the White House's COVID vaccine mandate this week after the order was challenged in the U.S. Court of Appeals. On November 12, 2021, the U.S. Court of Appeals for the Fifth Circuit granted a motion to stay OSHA's COVID-19 vaccination and testing emergency temporary standard. The court ordered that OSHA take no steps to implement or enforce the ETS until further court order. So basically until the court case is done. While OSHA remains confident in its authority to protect workers in emergencies, OSHA has suspended activities related to the implementation and enforcement of the ETS pending further developments in the litigation, posted the agency on its official webpage. The Biden administration has previously argued that the mandate was similar to other safety precautions, like mandatory hard hats when working on construction sites. This was a nationwide mandate on every person that worked for a company that had more than 100 people. Hard hats are only for specific jobs. We'll get into that. This is a tweet from Thomas Massey. Companies should cease implementation of Biden's OSHA vaccine mandate because OSHA itself has ceased. OSHA website, OSHA has suspended activities related to the implementation and enforcement of the emergency temporary standard. And we'll finish the article and then I'll show you OSHA's website as well. When this finally gets fully adjudicated, the validity of this requirement will be upheld. If OSHA can tell people to wear hard hats on the job, it can put in place these simple measures to keep our workers safe. White House Chief of Staff Ron Klain, screw that guy, whatever, on MSNBC. The president's order issued in September mandated all private businesses with more than 100 employees to require the COVID vaccine for workers with few exemptions. The mandate is scheduled to begin on January 4th, pending future legal challenges. So let's go over here, check this out real quick. This is OSHA's lovely website. See right here at the top. United States Department of Labor, Occupational Safe and Health Administration. Okay. Emergency temporary COVID vaccination and temporary or testing ETS. On November 16th, 2021, the U.S. Court of Appeals for the Fifth Circuit granted a motion to stay OSHA's COVID-19 vaccination and testing emergency temporary standard, publicized on November 15th, 2021. The court ordered that OSHA take no steps to implement or enforce the ETS until further court order. While OSHA remains confident in its authority to protect workers in emergency, OSHA has suspended activities related to the implementation and enforcement of the ETS pending future developments in litigation. So, that's it. It's done for now. Now, obviously, this court case is going to go on. It's going to keep moving forward. But for now, your job doesn't enforce this. Doesn't have to enforce this. There is no government agency pushing them to enforce this. There are no fines. There are no regulations that are currently active. There is nothing to make them do this. So if your company is still going forward with trying to implement any of this garbage, you go straight to the OSHA's website. You go straight to the court ruling and you look at them and go, here, So you're telling me you believe in this? You want to enforce this? All right, so check this out. I want to look over the court ruling a little bit because this is absolutely hilarious. All right, I'm going to leave this link in the description down here below. Because this link here, this one right here, this link down here in the description down below, so that way you guys can see where I pulled this from. I'm going to go over to my PDF version of it because I was actually able to highlight, because obviously I'm not going to read through this whole damn thing. It is 22 pages of legal jargon that, yeah, nerds like me kind of like. I mean, reading this was, basically legal porn for me. This was legal poetry. The smackdowns in this are just, beyond glorious the way they did this. I was over the moon with how they went about this. So we're going to start back up here at the top, and then we're going to go through some of the highlighted portions that I looked at. Specifically, just says obviously United States Court for the Fifth Circuit, yada, 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 all of that kind of BS. Let's see here. Let's see if we can get this to go down. Yeah, here we go. There we go. We're going to just have to skip down pages. So basically it's just saying up here at the top, the occupational self OSHA is reasonably determined June emergency temporary standards was not necessary to protect working people from occupational exposure to infectious disease, including COVID-19. This was not the first time OSHA has done this, refused several ETSs. So 6 were challenged in court, only 1 survived. The reason for the variety of this form of emergency action is basically extremely rare. I was reading this. Yeah, it was kind of wild that they ever thought that they could get away with any of this. So this is talking about who is filing for the mandate on the afternoon of the mandate's publication. Diverse group of petitioners, including covered employees, states, religious groups, and individual citizens, moved to stay and permanently enjoin the mandate in federal courts of appeals across the nation, finding cause to believe that there are grave statutory and constitutional issues with the mandate. We intervened and imposed a temporary stay on OSHA's enforcement of the mandate. For ease of judicial review and in light of pressing need to act immediately, we consulted our court's petition under the case captioned above. So this is just some of the highlights that I really enjoyed. So let's go down through here, find my first little spot that I highlighted. because some of the wording they use in here is just absolutely savage. So this is starting to get into some of the reasons why they did this. I love this. They specifically call out the president for knowing they couldn't get away with this through normal means. After the president voiced his displeasure with the country's vaccination rate in September, boo, not everybody wants to get your jab. The administration pored over U.S. code in search of authority or a workaround for imposing a national vaccine mandate. The vehicle it landed on was OSHA ETS. So they specifically call out the White House for doing this and knowing that they couldn't do this through a normal means. And this right here talks about Texas. Texas is one of the leading charges. Big shout out to our Attorney General. He's freaking awesome. I love that guy. In its brief, Texas makes a compelling argument that 555C1's neighboring phrases, substance or agents and or toxic or physically harmful, places airborne viruses beyond the purview of OSHA's ETS in the first place. To avoid going into unintended health threats, the act of Congress relies on the principle, company it keeps. So basically whoever you want to hang out. A natural first step in enacting lawful ETS is to show that employees covered by the ETS are in fact exposed to the dangerous substance agents or issues. Here, COVID-19. So this is what it goes down to. Of course, OSHA cannot possibly show that every workplace covered by the mandate currently has COVID-positive employees, or that every industry covered by the mandate has had or will have outbreaks. So basically saying that there is no emergency to every single person that is working, every single person this mandate covers. That's exactly what they're saying right there. Equally problematic, and this is another section, another one of their paragraphs as to why they're approving the stay. Equally problematic, however, is that it remains unclear that COVID-19, however tragic and devastating the pandemic has been, poses that kind of grave danger. They also go in here to talk about the actual threat to different individuals, if you've already had the vaccine, or if you've already had COVID and have natural immunity versus somebody who hasn't had the vaccine, versus a truck driver who sits around and is literally by himself for 12 hours a day, saying this can't possibly apply to everyone this broadly. It is thus critical to note that the mandate makes no serious attempt to explain why OSHA and the president himself were against vaccine mandates before they were for one here. Biden, all of them, Psaki, everybody said there would never be any mandates, that was absolutely, they were completely and totally against it, that there was no reason for mandates, it wasn't even legal. Even they thought that at the time. And then, of course, politics change. Biden cries about the fact that he's not getting his vaccine numbers to where he wants them. Everybody needs to get the shot. Why aren't you listening to me? All right, so now this starts getting into the list of the very specific reasons as to why they are granting this stay on OSHA being able to enforce this. Here under Section D, the public interest is also served by maintaining our constitutional structure and maintaining the liberty of individuals to make intentionally personal decisions according to their own convictions, even or perhaps particularly when those decisions frustrate government officials. I.e. Biden, why aren't you getting that? Don't get the shot. Yeah. They're basically calling him out here for being a big crybaby and not doing this. So there's a lot of other conclusions. This is the big final statement to it all, that the main briefing. In addition, it is further ordered that OSHA take no steps to implement or enforce the mandate until further court order, which means everything they wanted out of that mandate, poof, they cannot enforce it. There is literally no threat to your company as far as fines or any other actions from the government based on this mandate. There is no reason, they have no reason to enforce this whatsoever. I liked some of Stuart Kyle Duncan. He was a circuit judge that concurred. He brought up some other really good stuff that I'm not going to bore you with. This one, he brought up the Interstate Commerce Clause. Whether Congress could enact a sweeping mandate under its interstate commerce power poses a hard question. Whether OSHA can do so does not. I concur in granting a stay, which means he agrees OSHA does not have this authority. And I completely agree with them as well. So that's kind of some of the big news I wanted to get into for the week. It's been a lot of good stuff. Kyle Rittenhouse's trial, God bless the poor boy. We hope he comes out of this on top. It was a clear-cut case of self-defense, so we'll wait to hear back from that. I'll post stuff on the Facebook pages and the MeWe pages and everywhere else you find me. Jesse Carlson on social media, you can find me. I will post all that information as it breaks and as we hear something. So keep up to date with all the different channels. OSHA rule is out, okay? No enforcement. Tell your employer to buzz off. They can't enforce this. They have no reason to enforce this unless they want to be fascists on their own. Don't let them be fascists on their own. Also, finally got my t-shirt samples in this week. Here, let me move my dog tags out of the way. Common Man, Corpus Christi. I also have a Let's Go Brandon and a Fauci's Duplicitous Dwarf t-shirt. I'll wear some of those in the next video, but this is just our traditional logo on a nice shirt, so I'll leave links in the descriptions for the t-shirt store. There'll also probably be a little scroller down here at some point, so go check that out if you want to help support the store and help me do more of this full time. Once again, guys, this is Jesse with the Common Man, Corpus Christi, bringing you news and politics through a common sense lens. Thanks for watching, guys.